So I'm moving to a bigger office. This office that I've been here for 3 years now. Unbelievably, I've been here for 3 years in a very small office. I mean, I'm talking about just an office cube, just me. But you have to start somewhere in order to grow. And my experience has been that clients don't really care how big the office is as long as you are doing good work for them. So I'm pretty excited about moving to my new office. As soon as I get the keys and all that type of stuff, I'll give you a little tour and everything before I go in there and put the big rig bull print on it as far as the aesthetics. But today's topic is about understanding the different theories of liability in truck accident cases. So let's get started. So there are primarily three different types of liability or theories about liability when you're putting together the original petition. The first one is employer liability, and that's basically where the company driver or the truck driver is an actual employee of the trucking company. So in this situation, the trucking company is responsible for the driver's actions while they're acting in the course and scope of employment. Now, there are situations where you're dealing with 18-wheeler drivers and the driver may be high on cocaine, or they may be distracted at the time of the wreck because they were on their phone. And those are two examples that I put up here. A driver high on cocaine that causes a fatal wreck, a driver that is distracted on his phone and causes a wreck. Now, although the trucking company itself did not provide those items, the cocaine or the phone, in most cases, hopefully, to the truck driver, they are still responsible for the actions of the driver because he or she is still in the course and scope of employment of the trucking company at the time of the wreck. They're driving the truck even though they're high. They are driving the truck even though they're on their phone. They shouldn't be. So employer liability is the first one. The second one is lease liability, and that's when a trucking company leases a vehicle and driver, and that's commonly referred to as an owner-operator lease. The trucking company must have exclusive possession, control, and use of the vehicle, meaning that no one else, no other motor carrier has any say-so about what's going on with this vehicle. But it's also possible for more than one motor carrier to be responsible for the injury sustained. Because if, let's say, one motor carrier has a permanent lease on this particular vehicle, but another motor carrier employs this same truck for a single trip lease to a destination. If a wreck occurs in that period of time, then both motor carrier companies could be held responsible, depending on how the lease is drawn up. There used to be a time when everything around the theories of liability as far as lease liability was governed by placard liability or logo liability, meaning that the motor carrier company would be held responsible until they got their placards back from the person who was holding the truck. Now, 1986, I believe they changed that through some type of amendment. And now that is just kind of viewed as more evidence to prove the liability of one party or another. Generally speaking, though, everything is going to be looked at through the eyes of the contract or through the scope of what was drawn up originally in the written contract. The last one is negligent hiring, entrustment, or retention, what I like to refer to as HER. H is negligent hiring. This is the idea or the theory of liability that the trucking company should have known that the driver was incompetent when they hired the person, whether it was through a background check or a physical examination. They should have known that this person was completely incompetent and unable to safely operate a commercial motor vehicle on our highways. E is entrustment. negligent entrustment. It is an inexperienced or inability to safely operate the vehicle. So, like I said, this may be because of past accidents that the person has had. This may have been other jobs that they were fired from, where they got into wrecks before, but something should have alerted them to the fact that this driver was not going to be able to safely operate this vehicle. And the last one is R, negligent retention. That is basically when a trucking company learns during employment that the driver is incompetent, and they keep him or her on the road operating a commercial motor vehicle anyways. So let's say trucking company X has a driver that has been in 2 or 3 wrecks in the past 2-3 months or 6 months. Something should have told them that this guy is not safe to put behind a wheel, because this is a monstrous machine and is capable of a lot of damage on the roads. So all of this, the negligent hiring, entrustment, or retention, part C, could really be avoided by a quick database search through the PSP. And I won't really go into that, but like I say, if you have a negligent hiring, entrustment, or retention claim, that's something that should have never happened, because the trucking company should have done their job and did a background search on their employees. So that's the theories of liability. I hope that didn't take up too much time of this vlog, and that's it for this portion of it. Today's scratch that.